evening, everybody. I'm happy to see you all here on this wet and wonderful Tuesday evening. And I'd like to extend a very warm welcome to the 2024 John F. Morgan Senior Distinguished Faculty Lecture. I'm George Shepard. I'm a professor at the Emory University Law School, and I'm also president-elect of the University Senate and chair-elect of the Emory Faculty Council. And because of that, I'm had the honor of chairing the nominating committee for the Distinguished Faculty Lecture. This is a university-wide honor that is awarded every year. It was first awarded in 1996. It's a prestigious honor, and we ask for nominations from across the university. Then the nominations are assessed by a committee that is made up of the previous distinguished faculty lecturers. So, Rich, we have a job for you next year. And so I serve as chair of this nominating committee. So this year, like in previous years, we received many excellent nominations from across the university. So the committee had a daunting task to pick the lecturer, but we have a truly outstanding lecturer for you here tonight. So without further delay, I'd like to invite Emory's president, Dr. Fenves, to give some remarks.
All right, well, good evening, everybody, and thank you, Dr. Shepard, and thank you to the Emory Faculty Council for coordinating today's distinguished faculty lecture for all that the Faculty Council does in service to the university. So this lecture is named for the former Emory University Board of Trustees Chair, John Morgan. His official name is John F. Morgan Sr., but I know him as John Morgan. John is an accomplished business leader and a lifelong advocate of the humanities. John is an Oxford College, we don't call them graduates, we call them continuees, who then came to the Atlanta campus and graduated from the Goizueta Business School, actually long before it had the Goizueta name. But as board chair for Emory University, Mr. Morgan upheld a deep commitment to supporting faculty eminence. And this lecture honors his long-standing service to Emory and his dedication to our faculty. I saw that firsthand just last week when I went to see John Morgan at the Oxford College campus, which he is very devoted to, and our new dean of Oxford College. And he wanted to talk about the faculty at Oxford. But our faculty are our teachers. Teaching has been called the greatest act of optimism, anchored in the belief that we must prepare our students for a brighter and better future. Because imparting knowledge, teaching inspires change that can carry forward for generations with an incalculable reach and impact. The John Morgan Distinguished Faculty Lecture was created to recognize Emory faculty who have achieved excellence as scholars and as teachers, who embody our highest academic ideals and demonstrate exemplary scholarship. And this year's Distinguished Lecture is all of that and more. Now, if you know the Emory School of Law, or if you've attended any time in the past 4 decades, chances are you've met Rich Freer, the Charles Howard Candler Professor of Law, and it happens to be the next dean of the Emory University School of Law. Rich, I'm not done yet. Hang on. As a scholar, as an educator, and as a leader, he is quite simply one of our law school's true legends. A renowned expert in civil procedure, Professor Freer is a distinguished leader in this field, an award-winning teacher scholar whose lectures and books are in demand across the nation. During his nearly 41 years at Emory Law, he's been named Most Outstanding Professor by graduating classes at least 10 times. Outstanding Professor. Professor of the Year 5 times by Emory's Black Law Students Association. He has also received Emory's most prestigious faculty awards, including the Emory Williams Award for Excellence in Teaching, the Emory Scholar Teacher Award, and Emory's Law Ben F. Johnson Award for Faculty Excellence. I've had the pleasure of learning about Professor Freer's remarkable career when it came time last fall to determine who the next dean of Emory Law would be. His tenure in that position will begin on July 1st, and I look forward to the energy, the experience, and the creativity he will bring to the School of Law and to the entire university. But there's something you may not know about him. Professor Freer did not come from a family of lawyers. But by the time he was 5 years old, I am told, his mother predicted that he was destined to be one. Now, maybe that's because of his strong sense of justice, which is true, or perhaps he enjoys a good argument, which is definitely true. But Professor Freer took his mother's prediction to heart early on and chose law as his path. It was during his undergraduate studies as a sociology major at the University of California at San Diego that an inspiring professor opened his eyes to the idea of pursuing law as an academic scholar. And by the time he graduated, Rich Freer knew he wanted to blend the study of law with research, writing, and teaching. After graduating 5th in his class from UCLA School of Law, Professor Freer clerked for a federal district judge and a federal appellate judge, and then joined a litigation group in Los Angeles, where he practiced before leaving California and joining Emory Law School faculty in 1983. Today, he is a National Bar Review lecturer on civil procedure and corporations, and he has addressed more than 500,000 bar exam candidates nationwide. 500,000 bar candidates, lawyers in this country. He has served as an advisor to the American Law Institute's Federal Judicial Code Project. He is a prolific scholar and the author or co-author of 17 books and numerous journal articles, essays, analysis, and op-eds. A life member of the American Law Institute and an academic fellow of the Pound Institute for Justice. Professor Freer has served as visiting professor at universities around the world. And here at Emory, his teaching, research, and expertise is focused on civil procedure, complex litigation, and business associations. And his courses are always in demand, attracting more than 300 students a year. And I have seen this in my 4 years at Emory as I have traveled around the country, meeting Emory Law alumni. I can tell you literally thousands of Emory Law students have benefited from his teaching, his guidance, his mentorship, and his dedication to student success. And as I meet Emory Law graduates, I ask them, who was your favorite professor? Professor Freer, almost unanimous. We've got other great law school professors here, so I'm just telling you what I hear. So he joins us today to speak about a topic of both important and very timely. And the title of his talk is The State of American Civil Justice, a Story of Exodus and Transformation. So please join me in welcoming the 2024 John Morgan Distinguished Faculty Lecturer, Professor Rich Freer.
Thank you so much. Thank you, Dr. Fenves and Dr. Shepard, my colleague, for those very, very generous words of introduction. And I'm not sure my mother predicted so much as commanded, but at any rate, that is exactly right, 5 years old. Thank you, Dr. Gupta, and the special thanks to the Faculty Council for bestowing on me the privilege of delivering the John F. Morgan Senior Distinguished Faculty Lecture. I am truly, truly honored and humbled. And I also thank all of you for being here tonight on this rainy night. Now, we're going to talk about civil procedure. And one of the things that we need to figure out is how does that fit into the curriculum? The first-year curriculum at every American law school consists largely of mandatory foundational courses. Most of these courses, fascinatingly, are things that students know about, even students who have no particular exposure to the law before they come to law school. They know about these things. For example, there's a course on contracts. That's familiar ground because most students will have had contracts, perhaps with a cell phone provider. There's a course on real property, familiar ground. Most students have rented an apartment. There are courses on criminal law and on constitutional law, familiar ground, because these are part of common discourse and media coverage. And there's a class called torts, which is an unfamiliar word, but a very, very common idea. Torts are civil wrongs. Someone has harmed you, perhaps intentionally or through negligence. That's what torts is about. So students come into law school. Law school is new, but the incoming students have background, familiarity with all these courses. And then there's the course I teach. And George teaches civil procedure. Students have no background in civil procedure. What's this about? Well, the name gets us part of the way. Civil. We are dealing with civil cases, not criminal cases. We're not dealing with the government's effort to punish someone. Civil cases, the plaintiff sues the defendant, usually for compensation, for money to compensate for the harm allegedly inflicted by the defendant. And so we study how courts work in civil cases. And at first that sounds prosaic, maybe even boring. But on day one comes an important reality. Most of those other courses, when we think about it, are about rights that we may have. Rights under the law of contract, tort, property, under the Constitution, statutory law, rights. And so notice that not all rights are on the plaintiff's side. Defendants have legal rights as well, legal defenses, and we cherish our rights. But here's the reality. Our rights are worth nothing if we have no effective means of vindicating them. In the US, the baseline publicly funded mechanism to vindicate rights is civil litigation. When a person hurts you, or the government hurts you, or a business hurts you, you can sue. You can take them to court. Civil procedure then is not some mundane add-on to the curriculum. We study the process that makes our rights matter. Now, disputes are part of life. We all have them. And we have them with all sorts of folks, neighbors, family members, businesses. And thankfully, most of those disputes never get anywhere near a court. We work them out amongst ourselves, or perhaps with the aid of a mediator, but we always do that in the shadow of civil litigation. We know that if we don't work it out, one can sue the other, take them to court. And there is a distinct American model of civil litigation. And again, this is our publicly funded dispute resolution mechanism. But civil litigation in this country does much more than resolve disputes. If all we wanted to do was resolve disputes, have the government sanctioned method for that, we could have a clerk flip a coin to determine winners and losers. But that would have no moral ground, and it would have no legitimacy. Civil litigation does because it is rooted in normative values. What are they? Our civil litigation, first of all, is public. It's public. The courthouses are open. The proceedings inform the people and the media. If there's a case about a defective product, the world can know about it. We have access to the hearings and the documents. We see the strengths and weaknesses of the parties' assertions. We see the skill of the lawyers, the reasoning and demeanor of the judge. It's all on display. It's all public. Our system is also participatory. Litigants are heard. They get to tell their story. That's part of this sacred idea that I'm entitled to my day in court. And it's not just participation by the litigants. We, unlike most countries, embrace the jury, which reflects democratic values. In this country, adjudication is not entirely in the hands of the professionals. Lay people determine the facts of our cases. Our system is also transparent. It's also based in the rule of law. An adjudicated case ends with a judgment. That's a public document announcing the outcome with the imprimatur of the government. And our judges cannot simply rule. They must explain how they applied facts to law. They must justify their decision in accordance with the rule of law. And their decision is subject to appellate review by the Court of Appeals, further enhancing the rule of law. Now, our system is adversarial. And here we also part company with most of the world. Certainly continental Europe does not do it this way. In the US, each litigant is responsible for preparing and presenting its own case. And we bifurcate the process into pretrial and trial stages. In the pretrial, the parties, not the government, the parties investigate the facts. They sift the facts. And each litigant has very broad discovery rights. Within the rules, you may demand that your opponent produce emails and text messages and documents and other relevant information, no matter how damaging it may be to that other party. The pretrial phase focuses on the development of the evidence. And the focus is on what facts remain. What facts remain disputed? We're getting ready for trial. And the focal point is trial. That's the centerpiece of our model. That's where we resolve factual disputes. We believe that the search for truth is best realized when each party acts in self-interest, put through the crucible of adversarial presentation, cross-examination of witnesses. And the judge, as a detached generalist referee, rules on motions and things brought to the parties, but oversees this clash of self-interest to ensure that it's conducted within professional norms. But the parties run the case. In continental Europe, that's not true. They have the inquisitorial or non-adversarial system. There, it's the court. It's not the parties. The court investigates the facts and sifts the evidence. There is no distinction between pretrial and trial. Hearing after hearing, as much as it takes, and the idea is this continuing investigation by the court ultimately will lead to compromise, which the judges fully support and promote. Now, we also differ from continental Europe in that we're a common law country, opposed to a civil law country. In civil law countries, the law is largely codified statutes. We do have legislatures, and our legislatures do pass laws that regulate our behavior, but our courts make law. That is the common law, case law, judge-made law. And our judges have no authority simply to pontificate, declare the law in the abstract. It comes through the civil litigation system. Our judges have only the power to adjudicate cases, live adversarial disputes. And they look to precedent, prior case law. For the governing legal principles, and the appellate courts over time may decide that the law should change, and it does. It's alive. It evolves. It is the common law. So our civil litigation creates law. And I must say, most of the law by which we live our daily lives, tort, contract, property, that's all civil law. That's all judge-made law. Not only that, but the meaning of our written law, statutes, constitution, that comes from case law. It comes from these adversary proceedings. And so case law plays a role in telling us about appropriate behavior. It's actually part of our social ordering. So this system does much more than resolve disputes. That's our model. It is what the late Judge Friendly called the gold standard. And no paradigm is fully realized in practice. And the question for us is this: how does the reality today hew to that gold standard? And the last 40 years have seen two profound trends. One is an exodus of cases out of courts, and the other is a transformation of how we do civil litigation. And both of these trace to the litigation explosion. This is the late 20th century. We saw a dramatic increase of the number of civil cases filed. Why did that happen? It was a confluence of a lot of factors. For example, the Warren Court invigorated constitutional civil rights, and the Congress followed that with civil rights acts, creating more rights to enforce. Courts, evolving the tort law, adopted innovative theories. It was now possible to hold a manufacturer liable without showing negligence. That creates more cases. The centralized economy made it more likely that a single product or a single bad business practice might affect hundreds or even thousands of people. And at the same time, we were developing the modern class action, which made it possible to have those hundreds or thousands of claims in one case. Lawyer advertising came along. When I entered law school, lawyers could not advertise. By the time I graduated, they could. Good timing. And that obviously led to more cases as well, as did increased use of the contingent fee. And today we even see third-party financing of civil litigation. These factors and many, many more led to an influx of cases. And at the same time, the criminal dockets were increasing, largely because of the war on drugs. And the criminal docket forced these civil cases back farther in the litigation queue. The result, overload and delay. Now, how do you deal with overload and delay? Well, one way is exodus. Get the cases out of here. Get them out of court. The other is transformation. Let's change the way we do litigation in court. The exodus of cases out of courts is a very big story. And it includes the New Deal delegation of disputes to administrative tribunals. That was not done to alleviate court pressure. That was done as part of the New Deal belief that substantive experts, not generalist judges, should decide some cases. And administrative tribunals make us face the reality, as Judge Friendly said years ago, that not all disputes can be accorded the gold standard treatment. In a mass society, there have to be procedural tools for handling massive numbers of claims. We don't have the resources, for example, to have the full gold standard jury trials and all the rest of it for Social Security disability claims. We just cannot do it. And so we adapt. Something we'll come back to. Now, our focus tonight is exodus in a different way. It is exodus of cases to arbitration through contractual arbitration under the Federal Arbitration Act, the FAA. Here is how we set this up. We have two parties enter into a contract. Could be a contract for anything. They're going to sell widgets or they're going to build a shopping mall, whatever it is. And obviously the contract puts forth the terms and who has to do what, the responsibilities. But in that contract, we find an arbitration clause. And the arbitration clause says that if we have a dispute, we are waiving our right to go to court. And we submit to binding private arbitration. Now, historically, courts would not enforce these. But that changed 99 years ago. The Federal Arbitration Act, 1925, commands courts to enforce arbitration clauses. But we must understand the context, because how this is done today bears very little resemblance to 1925, indeed, all the way into the 1980s. Businesses lobbied Congress for the Arbitration Act. It was businesses who said, look, we want to be able to forego the formal litigation and all the delay and appeals and all that. We want a less formal procedure with an arbitrator who is an expert in this field. We just need to get back to business. Let us do this. And Congress said, yes. The only people who dealt with arbitration clauses then were businesses of relatively equal bargaining strength, and they agreed on it. They went in with their eyes wide open, said, yeah, we're not going to go to court on this. And for 60 years, the courts refused to enforce arbitration provisions for cases by individuals against businesses. Because we see that businesses started putting them into contracts with individuals, and the court said, no, we're not going to enforce those. Why? There's a wonderful case, Wilco versus Swan, 1953. Oh, what a great case. The Supreme Court held that an individual's federal statutory right simply cannot be arbitrated. The opinion was a love letter to the gold standard. Vindication of individual rights, vindication of federal policy demands the public, transparent, adversarial, judicial process. Arbitration is a pale comparison. Businesses persisted. They kept putting these ARB clauses in various contracts, including contracts of adhesion. Now that may be an unfamiliar term, but a contract of adhesion is one that's offered by the business on a take it or leave it basis. There's no negotiation. You either take it or leave it. In 1925, they did not exist. And in the 60s, they started getting common. And of course, they're ubiquitous today. Everyone in this room has signed or clicked onto a contract of adhesion. Your internet provider, stores, streaming service, they're all there. And they have arbitration provisions, but historically the courts would not enforce them. Why? You're an individual, you get access to the courts. But all of that's changed in the last 4 years. The court overruled Wilco versus Swan. The court enforces arbitration clauses in contracts of adhesion. So now, simply by clicking on an agreement, you do much more than agree to the substantive terms of that contract. You probably have relinquished your right to go to the civil justice system. You are going to go to arbitration, and the business decides how that arbitration is going to be done. The business chooses the provider. This notion has now swept the Supreme Court, and you now get unanimous decisions that, hey, you signed the contract, you didn't have to sign the contract, and the contract takes precedence over the gold standard at this point. And so today, individual consumers, investors, employees, think of this, patients, clients have no right to sue the business in court. You pursue private arbitration, and it's true for many, many claims. Violation of employment, anti-discrimination, securities, antitrust, consumer protection, claims for malpractice, wrongful death claims against nursing homes can all be swept into arbitration. There's an estimate today that 60 million American workers do not have court access to enforce their employment rights. They must go to arbitration. Now, is this a big deal? The Supreme Court does not think so. Today, it sees nothing at all special about civil litigation. It has completely forgotten the love letter it wrote to the gold standard in Wilco versus Swan. The public, transparent, governed by the rule of law process, not that big a deal. Arbitration's just as good. They're fungible. But folks, it's just not right. It's just not right. Arbitration is none of those things. First, it's not public. Arbitration hearings are private. The results are sealed in non-disclosure agreements. If a case concerns a dangerous product or an illegal business practice, the public's not going to know about it. There is no jury. The arbitrator may not even be law trained. There is no requirement that the arbitrator give us that reasoned application of law to fact and justify the decision in accordance with the rule of law. There is no written record. And judicial review of arbitration decisions is very, very limited. The fact that an arbitrator misunderstood the law is not necessarily a basis on which to set aside the arbitration ruling. What about the rule of law? And arbitrators' decisions obviously do not contribute to the development of the common law. Now, in 2022, Congress did step in and made a very, very important first step, because Congress now has amended the FAA to ban arbitration clauses for claims of sexual harassment and sexual assault. That is enormously important. Those cases deserve court treatment, but so do others. So this is an important step, but it's a first step. Now, we've shuttled all these cases then out of the courts into contractual arbitration. Let's go back to court. What is the state of affairs in the courtroom? And here we see the transformation. Over my career, we have seen a shift in focus of civil litigation, and it's driven by, justified by the litigation explosion. Judges are under enormous pressure. Make no mistake, that's true. There are a lot of cases, and the criminal docket is relentless. And a lot of judges are required to give public accounting of how many cases they have pending and their disposition times. This pressure has created this fundamental change. We have moved from a system focused on adjudicating cases, trying cases, to one focused on processing cases. Remember, the centerpiece of the gold standard is the trial. Now, historically, most cases settle. That's always been true. But historically, we kind of expected 20% of cases to go to trial. But that number has been falling and falling for decades. And recently, it has just fallen precipitously. In federal courts today, of all the cases filed, 1% will go to trial. 1% will go to trial. 0.7% of cases filed will ever go to a jury. As one civil procedure scholar says, the civil trial is approaching extinction. The pretrial phase is not a means for preparing for trial. We know we're not going to trial. The pretrial phase is an end in itself. There is no trial. That's why law firms no longer have trial departments. They used to. They're called litigation departments, pre-trial litigation departments. Now, consider the timeline of a civil case in federal court. In those courts, now in federal courts, we don't have small claims matters. These are fairly substantial cases, all of them. But think of this, even though they're substantial cases, if yours is the one case in 100 that's going to go to trial, how long does it take to get there? On average, 27 months. From the time you file to the time you get to trial, 27 months. What are you doing all that time? Well, you're very busy. You're engaged in pretrial litigation. The past generation is characterized by relentless front loading of cases. Court rules impose huge burdens and tremendous amounts of work on the parties in the early phases of the case. For example, in the first 90 days after a federal court case is filed, the parties must disclose categories of information to each other. Now that takes time. You got to find the stuff, sift it for privilege and the like. They're also required to sit down with the opposing party and put their cards on the table about strengths and weaknesses of their case. And they must pull together a plan that they present to the judge, a plan very detailed about how we're going to spend the next 2 years. We need to lay out for the judge. How we're going to spend those times. How long in pleadings, motions, how long in discovery, how long in joinder, all these things. Now, that plan gets adopted by the judge and it can be amended, but the point is you have to do it in the first 90 days, tremendous amount of work. And this front loading, there are many other examples, has altered the role of the judge in two fundamental ways. First, instead of largely letting the cases be run by the parties, what do we see today? What Professor Judith Resnick famously wrote about 40 years ago. She saw all this coming. Managerial judging. Managerial judging. The judge is hands-on. The judge is running the pretrial phase. And secondly, historically, judges did not push the parties to settle. The idea was, look, we're here to adjudicate the case. We're going to go to trial. And if you folks decide to settle in the meantime, great, great, great. But we're not going to push it. And all of that is gone now. The courts are very active in pushing the parties to settle. Increased numbers of conferences, mandatory mediation. And the rules reflect what I think is a stunning minimization of the traditional role of the American judge. The rules now don't say your job is to adjudicate cases. The rule says the job is to assist in the resolution, not adjudication, assist in the resolution. This focus on conciliation is so dominant that we actually have judges today saying it is a failure if a case goes to trial. How can that be? The centerpiece of our model is for some a sign of failure. It's a far cry from what the law students are expecting. It's a far cry from what the culture sees, whether it's Aaron Brockovich or The Verdict or Atticus Finch or Ben Matlock. We see lawyers in court, we see judges on the bench, and we see juries in the box. That's what we expect, but that's not the reality. In 1980, the average federal trial judge spent about 800 hours a year on the bench, in court, in the courtroom, presiding at trial or hearing motions and arguments, 800 hours. That number is now far less than half that. And in fact, there are districts in which judges spend maybe 200 hours a year on the bench. And this is happening while the caseload increases. Where are they? What are they doing? Well, they're working hard. I have nothing but respect for judges. It's a hard job, but it's a different job. They're in chambers. They're back in their office, ruling on motions, overseeing discovery, overseeing efforts at settlement. There's no public access to that. There's nothing for the public to see. And that's the way the job is. There are even studies that show how few hours a year the lights are even on in the courtrooms. That's not where the job is so much now. And so we have to ask this: are we in the process of rejecting the adversary system? Is that where we are? Our move toward this front loading of cases has an important ancestor. In the 1990s, we saw the same sort of front loading with reforms in England and Wales. They front loaded litigation in the same way we do. But they gave us the reason. And the reason was, we're going to make the parties incur greater expense early because then they'll see the wisdom of settling. Now, I suspect the same goal here, but I can't prove it because we've not had that debate. Those reforms in England and Wales were part of an overall national debate in the UK about the adversary system. And they decided not to go that way. And so they decided not to go with the adversary system. That's fine. Our transformation is not the result of any debate, none. It's incremental rules changes, a couple of court orders here and there. Now, don't get me wrong, settlement is not a bad thing. But the settlement culture, the idea, the presumption that every case ought to be mediated, that's not a good thing. We don't want our courts to become monuments to mediation. If you're the victim of identity theft, your bank account's been drained, if you have suffered some horrible attack, or if some business has harmed you, you want a realistic opportunity for full vindication of your claim. You should be able to get that. You would resent a system, the primary goal of which is to make you settle, sit down with the other side. Famous Law Review article years ago called Mediation with a Mugger. Really? You're going to make me sit down and mediate this case? Some cases need to be litigated. And the mindset now is, what we've forgotten, in the words of one judge, is that the word judge is a verb as well as a noun. Now, we've spoken about federal courts. What about state courts? People often ask about the American judicial system. And at one level, there's no such thing. There are 51 separate judicial systems. Every state has its own. The federal government has its own. Actually, more than 51 because DC, Puerto Rico, et cetera, all have their own as well. But they all embrace the same gold standard adversary system. How is it faring in state court? Oh, that's a very good question. State courts are hard to study, empirically hard to study. They're independent systems. There's no national clearinghouse for data. Federal courts are easy to study. It's one national system, and the federal government is extraordinary at pulling the data together. The data disparity has caused us in the civil procedure world to study federal courts far more than state courts because we have data. But that's a big problem. There are 14 million civil cases filed in this country every year. 98.2% of them are in state court, not federal court. Federal courts are tiny. Federal courts Very, very small caseload in comparison to the state courts. And what we are seeing now, this is one of the most exciting areas of research now. We are seeing greater empirical studies and data on state courts. We're just now learning that state courts have problems federal courts don't face. And we're just now learning some startling things. Now, remember, in federal court, these are mostly substantial cases. So unsurprisingly, in most cases, both sides have a lawyer. Makes sense. There are now data showing that in some state courts, as few as 25% of cases feature lawyers on both sides of the dispute. 75% of the cases, one side has a lawyer. They don't both have a lawyer. And we're beginning to hear about lawyered and lawyerless courts. Why? Because we're studying this in state court. And that's exactly what we're seeing. The data show in one state court, for example, almost 2/3 of the cases in that state court are debt collection and landlord-tenant. And more than half of the defendants had no lawyer. Had no lawyer. And most of those suffered default judgments. They just did not show up. I got to tell you, when you do not have lawyers on both sides of the case, you do not have an adversary system. So what we realize is, for a whole lot of people, civil litigation does not look at all like our gold standard. So what do we do? In light of all this, does it make sense for George and for me to continue teaching the gold standard in our courses? Yes, yes, yes. New generations of lawyers need to know what the system can be. They need to know the normative underpinning, public, participatory, engaging the community, transparent, rule of law, generating common law. So we will continue to teach the gold standard, but we must teach reality. Exodus and transformation are reality. Lawyerless courts are reality. And we need to consider innovation. And remember what we learned from administrative adjudication, such as awarding Social Security disability benefits. Not all systems will have all parts of the gold standard. And so maybe we need to reconsider some things. Maybe we need to rekindle the national debate about government funding of civil litigation. Maybe the non-adversarial inquisitorial system, maybe that is better in some kinds of disputes. Maybe we go to online dispute resolution. In England, they've shut down 100 courthouses because so many cases are now handled in online dispute resolution. All of these things are on the table. I certainly don't know the answer, but the gold standard has to be the starting point. From the gold standard, we must determine the irreducible minima that must be there in any procedural model we come up with, because it has to guarantee procedural due process. So civil procedure will continue to vex first-year students, but not for long. They realize our imperative is clear. Rights are precious things. And we must ensure that people have an effective way rooted in clear normative principles to vindicate those rights. Thank you so much. Yeah, questions? We have time for questions. Thank you so much. Anybody? Yes, please. Yes. Wonderful question. As to the latter point, the lawyerless courts, we are so in debt of the legal aid lawyer because most of those lawyerless people are indigent or close. They can't afford a lawyer. And so the legal aid lawyer is there. The problem is the legal aid lawyer is overworked and they're underfunded. And so one possible national debate, we've had it before, but we've never gone down this road. Is there a way to fund lawyers in civil cases? We do it in criminal cases. Is that something we want to do? That's a big national debate and a big lift. Now, on the exodus point with the arbitration, that has not been done specifically to alleviate court stress. What we have there is just this remarkable story of back and forth between business lawyers and plaintiffs' lawyers. And businesses, of course, got the FAA passed in 1925 at a point when the only arbitration clauses were agreed to. The problem with the contract of adhesion is you and I did not specifically agree to that. The waiver of court access. And what has happened in this back and forth is the businesses kept pushing. Let's put this in contracts, not contracts of adhesion, but contracts with individuals. And the court said, no, Wilco versus Swan. You have to be able to go to court. Then they pushed into contracts of adhesion and it didn't work and it didn't work and it didn't work. But finally it did. And what happened was the notion of primacy of contract. The idea is it's a contract. You signed it. You clicked it. You didn't have to do that. It overlooks the obvious fact that what we're doing here is waiving a very important right. And maybe, now think about it, contract of adhesion has a bad name to it. I mean, they're not bad things. I mean, how could, really and truly, are we going to sit down and negotiate every term of our cell phone? I mean, come on. They have to be kind of standardized. But maybe, just maybe there's a box you can click that says, tell you what, I'm on board with the contract and all the minutes and all that stuff. But if there's a dispute, I reserve my right to sue. Now, what'll that mean? I pay more every month than other people. That's okay. That's okay. At least then it's on our conscience. But it hasn't been. People, you really don't know how broad those terms can be. I mean, when you sit down and read through, we just scroll and click. And it's one thing to say, okay, I get 100 hours or minutes or whatever the cell phone thing is. That's great. That's fine. But when I've waived my right to have a court hear my claim, that's pretty fundamental. But again, primacy of contract. And now I must say the Supreme Court, you get these unanimous decisions. Just say, well, you clicked on it. There it is. So that's a debate. And I think we've lost sight of the gold standard. And we can't. Because it is a great thing. We need to figure out how we keep it alive. Never going to be realized 100% of the time. I get that. But you can't lose sight of it. John.
Thanks for a great lecture. Really quiet. I wondered about the difference between the UK and Wales versus the US on the question of paid attorneys. As I recall, the UK and other British Commonwealth countries imposed the cost of attorney's fees on the loser.
Yes.
And one, is that something that you see as a possible fix? Number two, does your judgment about that turn on different patterns that have expedite some of the concepts?
Thank you. Very good question. Here's the basic rule. The basic rule in most of the world is that the winner recovers her costs and her attorney's fees from the loser. So loser pays. So if I bring a case against you and it's a little iffy, and I lose, I'm going to pay your attorney's fees. That's a disincentive to suing. In the United States, the rule is different. In the United States, the rule is that the winner does recover costs from the loser, but costs do not include attorney's fees. Cost is a term of art. Things like filing fees, discovery fees, and the like. The big ticket item is the attorney's fees. And the attorney's fees in our system, each party pays your own way. And so you pay your own. And the argument has always been that if a plaintiff has to pay the defendant's attorney's fees, because it turns out we lost, we are going to pull in and not push new legal theories. That's the argument, is that we want people pushing the envelope. Let's develop the law. Let's get that emerging common law going our way. I might lose this case, but at least I don't have to pay the other side's attorney's fees. I think that's mostly the mindset there. And most of the rest of the world does not do it the way we do. And this also goes back to the adversary system. Most of the rest of the world doesn't do that. And this has been tied sociologically, perhaps, to an American mindset. An American mindset of the Wild West, I guess you could say. We are going to fight it out. We're not going to sit down and look, we may settle it. That's great. But that's not the goal initially. The goal is we're going to fight this out. There's going to be a winner. There's going to be a loser. And that's been written about as part of an American mindset as opposed to European mindset. On the normative point, we have debated this attorney's fee thing many times. And it's the rule, the American rule is that each party pays its own attorney's fees. However, there are hundreds of exceptions. There are hundreds of statutes and rules, and indeed courts have inherent authority to impose attorney's fees, to shift attorney's fees. And so it's kind of like the hearsay rule. In evidence, there's this rule that hearsay is not admissible. But then there are like George teaches that, like 19 exceptions. And my theory is, how is it a rule if there are 19 exceptions? And that's kind of where we're going with attorney's fees. I think you're not always going to get them, but it's not as stark as it sounds. And so in lieu of a national debate, you get legislatures stepping in and you get courts doing it as well. Yes. Not at all. Depends on what it is.
Well, I can see why legions of your students think you're such an outstanding professor.
Thank you.
So thank you, Rich. At the very beginning, you talked about class action suits. And could you say where class action lawsuits fit into the explosion of litigation? And is class action a democratization of people being able to assert their rights in the court system? Or, since my impression is most class action lawsuits are settled, is it just a rent-seeking mechanism that the courts have allowed?
Very good. And how we characterize it depends on which side of the V we're on, usually. Class actions allow many, many, many claims to be asserted in a single case. Now, there's an odd thing about this. A class action is brought by the representative, who is the plaintiff, and the representative is a party to the case. The class members are not parties. They're not joined as parties. And ordinarily, in our system, you cannot be bound by an outcome if you were not joined as a party. However, the class action is an exception, and this goes way, way back. And the exception is, it satisfies due process if you were adequately represented. And so that rep must convince the court that I'm doing an adequate job. And that's not a very high standard, is it? I mean, we would hardly ever say to someone, you're so adequate. I mean, that's not a high praise, but it has to be adequacy of representation by the representative and by the lawyer. And here's the problem with class action litigation and with characterizing. It is rife with conflict of interest. That's the problem. And so what we had in 1966, the class action was invigorated, the new class action rule, and we got a lot more class action suits. It's a huge part of the litigation explosion. But look at the potential conflicts of interest. You have, let's think about this. Let's say each of us in this room has a $30 claim. We've all been ripped off to the tune of $30 in violation of consumer protection law. None of us is going to sue. No one is going to sue for $30. It's just not worth the effort. But if there are 1 million of us, now you're not talking about $30 claims, you're talking about a $30 million lawsuit. Here you will get a lawyer. But notice the problem. All of a sudden, you have this million claim. A million claims for $30 a piece. If we proceed as a class action, what have we just done? We have just aimed a bazooka of liability at the defendant based on one outcome of one trial. You want to go to trial and risk $30 million? Probably not. So if a class is certified, you can file a class action, and as soon as you file it, it's a putative class action. It's not a class action until the court certifies it. And so we're going to have all sorts of great litigation about should it be certified? Do you satisfy the rules? And that certification is the watershed event. Because if certification is granted, the defendant now says, I'm not going to roll the dice for $30 million. I will write a check. Make it go away. And there are empirical studies that show this happens even when claims are weak on the merits, because you're just not going to take that chance. On the other hand, if certification is denied, what do we have? We have a bunch of $30 claims, and no one's going to bring that suit. Now, what have you done? Now you're worried about the deterrent effect of the law. The defendant got away with it, unless the administrative state or criminal law steps in. So there's this balance between the compensatory view of the law and the goal of the law and the deterrent goal. And notice the conflicts. The defendant, now let's say the class has been certified. $30 million liability you're facing. What do? I'm going to overgeneralize here. You're going to go to the plaintiff's lawyer and say, look, let's work this out. Okay, let's work this out. I'll write a check for $8 million, 7 million of which go to you in attorney's fees. And the other million will be distributed somehow through coupons or some such. The defendant is acting rationally. The defendant wants global peace. Let's get this thing done. But notice the conflict. Now the rep and the rep's lawyer are saying, gosh, I could pocket $7 million for a few months' work. And the rep is always going to get a bonus on this. So the rep has a $30 claim, but you're going to give $10,000 to the rep. The rep's happy with that. Plaintiff's lawyer is happy with that. Defendant's happy with that. Who has to step in to protect the class members? The judge. The modern class action is responsible in large measure for this transformation of a judicial role, because now the judge, instead of just being the referee, the judge is a fiduciary. Somebody has to look out for the interests of those class members. Are they being sold out? Judge has to do that. So class actions are just endlessly fascinating, and they've gone in waves. There are years when not a lot of them, and there have always been these predictions, oh, the class action is dead and all the rest. They're not dead. They're alive in federal court and they're alive in state court, and we're in a relatively robust period of class litigation. It is an enormously helpful tool for vindicating mass claims. but it's rife with conflict. George.
Do we have more time now, or is it?
Seven. The one last quick question with a quick answer.
I'll make it a quick answer.
It seems like in a robust economy like ours that's growing, you would expect there to be a litigation exposure. That's a healthy thing to happen with a growing economy, with the stock market is tripling. You expect there to be a proportionate increase in the number of suits. So, and it seems like the problem here is that we just don't hire new judges to take on the additional caseload. Why is that? And isn't that the solution? All the problems you're talking about are just the results of judges scrambling around when they have too much work. Why can't we get more judges?
Yes. Wonderful question. The number of federal judges is very low. And when we think about it, of all the judges in the country, fewer than 800 are federal judges, federal trial judges, Court of Appeal, and the 9 Supreme Court justices. Congress has not increased the number of judges much through the years. Part of it's budgetary. Part of it is there've been some research about this where they say, look, the people who are federal judges kind of like being in an exclusive club. They don't want thousands more judges, but I don't know if there's anything to that. But it seems always to run into the fiscal problem. And state courts really don't have a lot of money in most states. They really don't. So it's a funding problem. And what you see is more delegation of judicial functions to adjuncts like magistrate judges and so forth. And so that's just trying to keep their heads above water. I agree with you. It would be a nice, easy fix, but historically it hadn't happened.
Thank you so much, Rich.
Thank you. Thank you.
Wow, thank you so much. I have to say, I have learned a lot. And one of the things I've learned is I need to have some more lawyer friends. You know? I'm Nitika Gupta, I'm chair of the Faculty Council, and I would like to invite President Fenves to come up and accompany me in this real honor and privilege of presenting this award, Distinguished Faculty Lecture Award to Dr. Freer.
Oh, okay. Thank you.
And yes, I would like to invite everybody to a reception in honor of Dr. Freer. And thank you, everybody, for being here on such a rainy day. But it was a fabulous, fabulous talk. Please join us for the reception.